The following audio recording has been designed for learning purposes only. Do not share, distribute, or provide any type of copies, or this audio lesson will not be made available to you. Good luck with today's lesson.
Hello class, today we're going to talk about Chapter 41, Partnerships. The Uniform Partnership Act and the Revised Uniform Partnership Act are in effect in 49 states, and they will govern partnerships and the rights of partners. Now, a partnership is a voluntary association of two or more persons to carry on as co-owners of a business for profit. The partnership may also be referred to as a general partnership. Basically, though, there are two essential elements for a partnership to exist. They are a community in interest and a sharing of profits. In the general partnership, the parties may contribute capital or services or both. The general partnership isn't always regarded as a separate entity. There are certain following characteristics for a partnership, and they are voluntary agreement, contributions of capital, service, or both, co-owners, and for-profit. If you kind of look at the graph, I have partnerships and how they differ from agencies, unincorporated associations, and joint ventures. So if you kind of look, you'll see here in the chart that we have the business format, whether it's an agency, unincorporated association, or a joint venture. How is it different then from the partnership? If you're an agency, you're going to be different because you have co-owners in a partnership. Where an agency, it's a person working on behalf of another party entering into contracts with a third person. Basically, it's the agent is working on behalf of a principal, entering into contracts with that third party that would then be between the principal and the agent. An unincorporated association is going to be different from the partnership because the partnership is generally run for profit, where unincorporated associations are generally run for nonprofit. And the joint venture we mentioned last class is going to be different because those are when you gather for one specific reason, where a partnership you're going to continue to exist until the partnership no longer is there. So it's often difficult to distinguish between the joint venture and the partnership. However, this difference doesn't have serious legal consequences because the rights and liabilities of partners in joint ventures are the same in all important respects. Further, partnerships can be created by contract or by estoppel. Now, partnerships are based generally upon the partner's agreement, either expressed or implied. Partnership agreements, however, don't have to be in writing unless it's required by the statute of frauds. The partnership agreement may also be called Articles of Partnership or Articles of Co-Partnership. An agreement should carefully spell out all the terms and rights of the parties. However, often individuals create a partnership and partnership liability by their conduct and its appearance to third parties. Several factors can influence the determination of whether a partnership exists, but the sharing of profits creates a prima facie presumption that the partnership exists. Now, I said you don't always have to have the partnership agreement in writing. Why would you really want that in writing? Think about this for a moment. Why would you want it in writing? Because if something ever goes south with the partnership, at least you know if you guys were splitting the profits and losses 50-50, or maybe somebody had contributed more money and was supposed to get 60% of the profits and you were only to take 40%. By having that detailed in writing, then the court would know that you weren't doing a 50-50 split, it would be 60-40. Because if you don't have a writing, the court is going to presume that everything is 50-50. Let's talk about how partnership liability can arise through estoppel, as when an individual allows himself to be held out as a partner so that third persons are led to believe that the individual and his assets and creditworthiness are part of a partnership. Let's look at the following example. We have Donald Trump. Donald happens to own a retail business as sole proprietor, and for the purposes of obtaining credit from John Money, he represents to John that Bill Gates, who's a wealthy businessman, is a partner in Trump's business. Now, Gates knows about Trump's statements, but he fails to advise John to the contrary, although he could easily do so. John relies on Gates's credit and status in the community, and what does he do? He extends then the credit to Trump, which he otherwise would have not done. Is Gates then stopped from denying that he's a partner in Trump's business? Insofar as this credit is concerned, Gates will be stopped from denying that he is a partner, and he may be held liable as if he were in fact a partner in Trump's business. We mentioned that partnerships may be created even though there isn't any written partnership agreement. If a party is claiming that a partnership exists, that party has the burden of proving the relationship. The law looks to the substance of what is done. How does one then determine the existence of the partnership when there isn't any specific agreement? This is where the courts will look at the party's intent as expressed by their acts or agreements. They'll look at things such as control, sharing of profits and losses, sharing of the profits, gross returns, co-ownership, contribution of property, and fixed payment. So let's look at some of these factors. If we're looking at control, that's going to be really significant in determining whether an individual is a partner. Strong evidence will be shown by the sharing of profits and losses that a partnership exists. If we're sharing profits, that's going to give you a prima facie evidence of a partnership. Prima facie just merely means on its face. The gross returns, that could give you slight evidence of the partnership, whereas the co-ownership is not necessarily evidence of the partnership by itself. And if you're really not contributing any property, that lack of contribution does not necessarily mean the individual is not a partner. So again, the court will look at all these factors when they're determining whether or not you have a partnership. Now, generally, joint partnership of property, contribution of capital, and sharing of gross income will not establish the partnership. But like I said, the sharing of the profits of the business is going to be prima facie evidence that the partnership exists, except when it's received as payment of wages or bonuses, of a debt, of an annuity to a widow, as interest on a loan, or as consideration for the sale of the goodwill of the business. For income tax purposes, the partnership is simply going to be an aggregate of the partners, and the income and losses simply will flow through to the partners. Partners' rights are going to be determined by agreement, or if they have not provided for such in their agreement, by the Uniform Partnership Act. Now, the name of the partnership may require registration for protection, but that doesn't necessarily have to have a firm name in the absence of a statute. A firm can't be like another one. Also, any person who's competent to enter into a contract may be a partner. There are various classifications of partners, including general partners, nominal partners, silent partners, secret partners, and doormat partners. So let's kind of look at the partners and we'll detail them. What is a general partner? This is generally going to be someone who's in the public. They have active participation in the partnership. Nominal partners are going to be held out as partners, and they may be liable as partners. Silent partners are a little bit different because they have no active partnership, and they may be known to the public that they are partners. Secret partners are people who have active partnership, however, they're not known to the public as being partners. And dormant partners have neither active partnership nor are they known to the public as partners, so therefore they're unknown to the public. Partners in a partnership have express authority as provided in their partnership agreement and customary authority according to the nature of the partnership business. There can be limitations on a partner's authority provided in the partnership agreement, but third parties must be aware of the limitations. There are also prohibited transactions for partners, including an agreement to seize business, to act as a surety, to submit the partnership to arbitration, to confess a judgment, or to assign for the benefit of creditors. All these actions will require unanimous consent. Let's talk about the duties of a partner. Duties of partners include loyalty and good faith, obedience, reasonable care, information sharing, and accounting of the financial status of the partnership. The rights of partners include management authority. They can inspect the books, share profits, contributions, and indemnity. In the absence of an agreement, the partners are not entitled to compensation. Liability. Partners are going to be jointly liable on all partnership contracts, and they're liable to other partners for any breach of duty. New partners are going to be liable to the extent of their capital contributions for obligations in existence at the time of their admission, and they'll have full liability for any obligations occurred after admission. Partnership creditors will have priority on partnership assets, and individual partners' creditors must first exhaust the personal assets of the partner. Partnership property consists of any property combined by the partners or acquired for the firm or with its funds. So if you contributed any of the property and all that, we will put that as part of partnership property. Now, title to partnership property may be carried in the name of the partnership, or it could be carried in one or more of the partners' individual names. Title to partnership property then is going to be held in tenancy and partnership. Tenancy and partnership is going to be similar to joint tenancy when we talk about the passage of title upon the death of one of the partners. If you have creditors, the creditors of the individual partners can attach the value of a partner's interest, but they cannot attach the partnership property itself. And finally, how do we dissolve a partnership? Dissolution occurs when the partnership ceases to exist as a going concern. Dissolution can occur through the conduct of the parties or by operation of law. When we're talking about operation of law, we're talking about death, bankruptcy of the partnership, or any partner or illegality, or by decree of the court. Upon dissolution, the parties may continue in certain circumstances, or they may wind up the firm's obligations, liquidate, and terminate. Distribution of partnership assets then, upon liquidation, is going to be controlled by the Uniform Partnership Act. This is Chapter 41 in a nutshell. If you have any questions, please make sure to email me or post them in the discussion forum. Thanks.
Good luck with today's lesson.